Good morning and welcome to Legal Lens on Daily Insider TV. I am your host, Latif Adeleke. This morning, we'll be analyzing the political issues around the recent presidential election that saw the emergence of Bola Tinubu and Shettima. Of course, we've brought to you an expert and a legal luminary who will be dissecting this topic and answering our questions, at least to shed light to most of these issues in the political permutation in our country. I'm very excited to welcome Barrister Salaudeen Olaitan. You're welcome, sir.
Thank you, sir.
Thank you. So, Barrister, as we can see, there are a lot of permutations going on around our political structure. And of course, the most recent is the inauguration of Bola Tinubu, which of course happened on 29th of this month. So with your legal experience and even within the confine of the law, do you think it is legal and constitutional for the CGN to swear in a president despite the bulk of petitions in the front of tribunal?
Yes, it is legal and constitutional to swear in any candidate declared winner in an election, and for such a person to be sworn in. The swearing in of President Bola Tinubu is legal because, one, he took part, he participated in the presidential election, and the INEC declared him winner of the election. Having satisfied the requirement of declaration, the next step constitutionally is for him to be declared and then to be sworn in as president. What the law says is that once an election has been held and the result is declared, such a result is prima facie correct. Whosoever is aggrieved by anything regarding the declaration of somebody as winner of an election, the law provides that such a person has a right to go to election petition tribunal, whether at the governorship election or presidential election as concerned. So the swearing in of President Bola Tinubu as President of the Federal Republic of Nigeria by the Chief Justice of Nigeria is legal and constitutional. So there is a legal justification for that, because even Section 139 of Electoral Act provides that whosoever is declared winner will be in office, even if the petition filed challenging his declaration is affirmed by the presidential election petition, that, for instance, if the sitting president, his election is now nullified, so and such the president files an appeal, what the law says is that he is still allowed by law to remain in office pending the determination of the appeal filed against the decision of the tribunal.
Thank you so much, Barrister, for shedding light on that issue. But of course, recently, even before the inauguration, the vice presidential candidate of the Labour Party, Ahmed Dati, was on national TV saying that swearing in that ticket or that election, swearing in Bola Tinubu is unconstitutional and a slap on our democracy. Of course, our barrister has shed light to this because we know that this is one of the major issues around the political structure. Of course, barrister has established that it is within the constitutional arrangements to swear in president even while a petition is in court. Thank you so much, barrister. One other important issue is the issue of and in the constitution. In the recent election, we realized that Bola Tinubu did not win or did not get 25% of legal votes in Abuja. And of course, it is clearly written in the constitution that for anybody to emerge as the president of the Federal Republic of Nigeria, such a person must win 2/3 of the states and 25% of Abuja. We want you to shed light on this. Is 25% of Abuja, of legal votes in Abuja, compulsory requirement for a presidential candidate to emerge as our president?
Thank you. The opinion expressed by the vice presidential candidate of Labour Party, that is Baba Ahmed Dati, that swearing in of the president-elect then will amount to a non-constitutional individual is constitutionally incorrect. What the section 3134 of the Constitution of Federal Republic of Nigeria 1999 as amended says is that the requirements for declaration of a candidate as winner of a presidential election, it states that that person must have scored the highest number of votes, of lawful votes cast in the election, and that he must have scored at least 1/4, that is 25% of the votes cast in not less than 2/3 of the states of the federation and the FCT Abuja. So I'm aware that there are divergent opinions and views on the implication of the use of hand in that subsection of section 134 of the Constitution. However, there is something we call legal precedence, so that the interpretation and the legal implication of the use of hand in that section should not generate much controversy, because there are decisions of Court of Appeal and of course Supreme Court that have explained the position of FCT Abuja, and also the use of hand in that section. I think what some people are of the view that the 2/3 of 36, which is 24 states, that if somebody has scored not less than 25% of lawful votes cast in each of the states, that it is compulsory that such a person to be declared winner of presidential election must have also scored not less than 25% of lawful votes cast in FCT Abuja. That is the legal implication. Some people have the view that that's the legal implication of the use of hand in that section. However, I think there's a Court of Appeal case between Babangpai and I think President Federal Republic of Nigeria. It's a Court of Appeal case wherein the Court of Appeal, in that case, was of the view that the FCT Abuja will be treated and will be deemed as a state, that it will not be treated as a state that is inferior to other states or superior to any other state of the federation. And also in Bakari, that is a case decided by the Supreme Court, Bakari and Ogundipe. So the Supreme Court is of the view that the FCT Abuja will be treated as a state, which means that saying that whosoever has scored 25% of lawful votes cast in each of a state of federation, not less than 2/3 of the entire state of federation, must have also scored 25% of votes, of lawful votes cast in FCT, will amount to treating FCT as a superior state. So since these decisions say that FCT will be treated as a state, so and the law, the constitutional requirements as stipulated in section 134 of the constitution says that a quarter, 25% in each of the states, not less than 2/3 of the entire state, which means that if somebody scored 25% in any other state, not including FCT, and the number of the states in which such person has scored 25% votes is up to 2/3 of the entire state of the federation, that person is home and dry. And if such a person has also scored 25% of lawful votes cast in FCT and any other state, that person is home and dry. So saying that in the 2/3 of total number of states that somebody must have scored not less than a quarter must include FCT, that will amount giving FCT Abuja a superior state. So and that will make our electoral system very controversial, because a special treatment of position is given to a state more and over other states of the federation, against the settled position of the law that says that the FCT Abuja will be deemed to be a state of the federation, not superior or inferior to any other state.
Thank you so much, Barrister. Before we settle that, people who are of the opinion that the president is supposed to have 25% of Abuja are saying that the president is the governor of the FCT. And of course, in a country, for you to be a governor of a particular state, you must win a particular percentage of lawful votes in that state, of course, to gain the confidence of the people, so that they will feel like they are the one that puts you in the position. So if we say that it is not compulsory for a president to win FCT, we are saying that it's not compulsory for a governor to win an election in the state before he rules the state. What do you see to that?
I think few days to the presidential election, court ruled that the allegation of a double nomination leveled against then vice presidential candidate of APC, now vice president of Federal Republic of Nigeria, Senator Shettima, that there's nothing wrong, legally wrong in it, that allegation was not true. So, and that was the decision of the court, that the allegation of double nomination, although there are other grounds for which the court arrived at that decision. So, but that matter is now settled, that the allegation of double nomination, is not true. And the other ground is that the PDP and another people that were parties to that suit, that they are medusom interlopers, that they are dabbling into issues that do not concern them, that and another ground like that. Then the issue of the allegation, leveled against President Bola Tinubu in relation to having a case abroad wherein he forfeited a particular amount of money to the government, that remains an allegation. That remains and of course, I am aware that that is part of petition, is part of forming the grounds of the petition filed by the Labour Party against President Bola Tinubu, that he should be disqualified, and then because of that issue. I mean, without prejudice uh, to the case before presented by various petitioners before presidential election tribunal, because once a matter is before the court, we are not supposed to be discussing it deeply, except when such a matter has been determined. One can offer his legal opinion on same. What I know is that the case referred to is a civil matter, and then that case has happened now. I mean, for more than 10 years ago. So I don't want to say much about that, so that one will not be accused of sub judice, that is dealing in matters that was already put before the court.
Thank you so much, Barrister.
Yes, sir.
So with the look of things, there is probability that the dice might actually roll in favor of any of these parties. So, peradventure, the court rules that Asiwaju Bola Tinubu is not qualified. This shows that, does this mean that the election will be nullified and another election will be conducted? Or who will automatically have the opportunity out of other presidential candidates in the recent election?
I think Section 134 of the Electoral Act provides for grounds for which one can challenge the outcome of an election. So it provides for non-qualification, that one can challenge the election of somebody, that is of a candidate declared winner, so on the ground that he or she at the time of the election was not qualified to file or contest or take part in the election. Also, one can challenge the results of an election on the basis that what the Electoral Act refers to as invalid election, based or on the reason of non-compliance to the provisions of Electoral Act or corrupt practices. Also, one can challenge the result of the election based on the fact that the candidate declared winner or returned as elected votes cast in the election. So each of these grounds attracts different legal effects. For instance, if an election of somebody is nullified on the ground that such a person at the time of the election was not qualified, then the legal effect of such is that the person that has second highest number of lawful votes cast in that election will be declared winner, having satisfied other constitutional requirements regarding to his participation in that election. So then, if somebody's election is nullified by the tribunal on the basis that the election was invalid, then fresh election will be conducted. So, and whosoever has highest number of votes, having satisfied other requirements of the law, will be declared winner. Then, if somebody's election is nullified on the basis that he did not score highest number of lawful votes cast in that election, then somebody that has highest number of lawful votes cast in that election, having satisfied other requirements of the law, will be declared winner of that, because it has happened in the past election that somebody who has highest number of lawful votes cast will be shortchanged and another person will be declared winner. So, and the interloper will be saying that, okay, when we are in the government, you go to court. So in such a case, if it is proved and the person declared returned as elected is removed, so then somebody who is the lawful owner. So
Thank you so much, Barrister. Is there any superiority to this law? For instance, the Labour Party and, of course, Peter Obi is actually challenging the victory of Bola Tinubu on the three grounds. The ground of candidacy, that Bola Tinubu is not qualified enough, even qualified at all, to be a presidential candidate. And also, on the ground of corrupt practices, they are saying that INEC did not follow their guidelines. Of course, the use of beavers and all the issues surrounding it. And of course, in the issue of lawful votes, because of course, Labour Party is saying that it is compulsory under the law for a winner of presidential election to win the FCT or have 25% of the federal capital territory. So Labour Party is challenging the victory under all the three grounds. So if the court now find out that they are actually right under all the three grounds, is there any superiority? Will the election be nullified, or the winner, another winner will be declared, or which of the two will surface?
it depends on the ability, the sources, or otherwise of the petitioner. In this wise, the Labour Party to prove his case already put before the presidential election tribunal. The onus is on the petitioner to prove his case to the satisfaction of the law. It is not possible for all these petitioners to be right and then on the same, to be on the same footing. So because the three petitioners cannot become, I mean, the presidents. We cannot have three presidents at the same time. So which means that the complaints and the prayer, and then probably the belief of some of these petitioners, I mean, may be far from the truth. Because if, for instance, Atiku Abubakar is claiming to be the winner, so, and legally his claim is genuine and true, so, and eventually he succeeds in his petition, so definitely Mr. Peter Obi, I mean, cannot become president. The same thing for Mr. Peter Obi, and of course the candidate of APM, I think. So in us, it depends on the grounds, I mean, which the petitioner is able to convince the tribunal, because as I mentioned earlier, each of these grounds attracts different legal effects or implication. So if somebody challenging the election of another person, that is the petitioner, succeeds on the basis that the person declared return as elected was at the time of the election not qualified to have taken part in that election, then somebody who is qualified and is second highest, has second highest number of lawful votes cast in that election, happen satisfy other requirements of the law, I mean, will be declared the winner of the election. So the circumstances will determine which way the result of the petition filed by the various petitioners, I mean, will go.
Thank you so much. Our viewers, you can see that Barrister has done justice to each political issues and political permutations going on in our country. And not just that, he has pointed out the loopholes in our judiciary system. And of course, he has put out strategies that can enhance better judiciary system to ensure that justice is duly served. So, Barrister, what's your advice to the government, to powers behind the judiciary system, and even to our people, to the whole Nigerian?
Regarding the political matters, I think what we call internal mechanism, that is how political parties ensure that they manage their affairs in such a way that people who may feel aggrieved by a particular incident or result, will know that things are done rightly. So instead of cross-carpeting, then filing matters in court in order to settle scores. So political parties and then politicians to do things legally and ensure that the will of the majority prevails. Then the government should also ensure that our judicial system is improved. More judges, and then more staff, and then facilities should be improved in all our courts. So in order to ease administration of justice and the responsibilities of the courts. So then I think there are people who are found wanting, who are judicial officers and are found wanting, to also be exposed and punished accordingly. So if people know that once there are infractions, that there are consequences, so I think people will be wary to do unlawful things and then to cut corners. So let leaders do things rightly and ensure that they provide quality leadership, listen to the yearnings of the people. Let stakeholders in different sectors be involved in whatever policies that they are going to formulate. And then I want to appeal to the new leaders, political leaders that we have, that they should not renege on their promises that they made to the people, and then let there be transparency, let there be justice, and let people know that somebody is in charge who is sensitive to their yearnings and who is ready to do things rightly. So because once the head is rotting, the whole body is nothing.
Thank you so much, Prof. We've really gone a long way, and it is a very, very exciting moment with Barrister. So we will be going right now. We'll be seeing you and coming up on our program, Legal Lens, with other legal practitioners in our next session. Thank you for watching. Bye.